Good evening, this is John Milburn for Laws 11059, Statutory Interpretation. We're into week 7 and tonight there is a theme, and the theme is be ready to argue. Now, the best way to argue, of course, is to have knowledge. So that means read the material and be ready to argue the toss. One of the great things about law, as I've mentioned before, is the fact that there is not necessarily a right or a wrong answer. So when we talk about being ready to argue, I don't mean be argumentative, but be constructive in one's argument. The courts expect it, they require it. Now, when you read the material, if you read a case, I suspect that many of you, and myself included, tend to come to a judgment about what the decision should be. One of the great things about law is that you may find yourself in a situation where you may have a view on a certain thing. You may come to a decision that this is what should happen, or indeed what might happen if the matter goes before a court. But remember, of course, that our role is to argue the situation and not necessarily come to a decision in terms of in terms of inflexibility. Sure, we need to provide an opinion to a client as to their prospects of success, but if the client says, I want you to argue this position, you may think it's not the right way to go, it's not likely to succeed, but provided it's arguable, then your role as a lawyer is to argue. So when I say that tonight's theme is to read and be prepared to argue, I mean to do that in the context of our role as a lawyer. So why would it be the case that it's appropriate for a lawyer to argue a case that they don't necessarily believe is likely to win, or they don't believe is necessarily arguing for a just outcome? Why do we do that as lawyers?
For your client?
For your client, yep, exactly. A bit more to it than that. Our job, says Melissa, yes. So it's your job to represent your client, but you have other duties as well. Yes, Sharon?
Because everyone's entitled to legal representation.
Exactly, that's a really important point. It's not your case, it's the client's case. Any other thoughts? Now, we have a duty to the court, and I'm going to ask you this. How can it be that on Monday you stand before a court and you argue vigorously in favour of a proposition, and then on Tuesday you stand before the same court or maybe a different court and you argue vigorously in favour of the opposite proposition? Doesn't that make lawyers look really bad? Test and challenge, says Melissa. Number one case is not the same. Maybe distinguish them on their facts. Don't people get annoyed with lawyers, you know, just being convenient with their arguments? Perhaps if I could put it this way. The way the system works best, I think, is where a court is required to make a decision on a certain set of facts where both sides of the argument have been promoted in an ethical and very competent manner. That way, the court gets to decide either between those two arguments or, as we would have seen in statements made by Justice Kirby, maybe a different way altogether. But it's important for the case to be presented capably, competently, and vigorously from opposing viewpoints. What that means is that potentially a lawyer briefed in different cases may have to argue against a position that they argued for, you know, the day before or the week before or the month before. But that's all part of the system. And bear in mind, of course, that lawyers' role is not to make the call. The lawyer's role is to argue for the position for the benefit of their client, but in doing so, to do it ethically. Does that make sense? I've tried to explain that in a way that is appropriate. If anyone has a problem with that or doesn't understand what I'm getting at, please let me know. Now, the relevance of that in statutory interpretation is that you may often find yourself called upon to argue something in relation to the interpretation of a statute that you don't necessarily agree is right, but you do so ethically because it is arguable. Now, in law, it's not always easy to determine what is right. In other words, just because you don't think that that's necessarily the right answer, that shouldn't stop you from arguing it, if that makes sense. Think about it this way. In the High Court, we may have a certain situation that's put to the High Court judges and they don't all agree. And you would have seen that in statutory interpretation very often. In fact, most of the time, I would venture to say, the cases that are referred to in the textbook are split decisions in the High Court. Has anyone noticed that? It might be 5 judges go one way and 2 go the other way. You've noticed that? So what that says to me is that even at the highest level, the judges won't always agree. And you would have seen in those case studies that Michelle Sanson has provided to us very well, that she says if you decided that this is the right way to go, then you agree with A, B, D and F, but if you went the other way, you've agreed with C, E, G and L, if you know what I mean. So cases will often be flipped on appeal from the original decision through to the appeal court, through to the High Court. Different people have different views. And that makes it really difficult to advise. But it also provides you with an opportunity and a degree of comfort in that if you honestly say, this is my view, however, a court may see it differently, that doesn't mean you're necessarily a lawyer that doesn't, is not able to promote an argument or come to a decision. It's just that you're being realistic with it. And your job is to argue the toss and put it forward what you think is the right answer based on your client, the right argument based on your client instructions. Now, does anyone wish to make any comment about that, Shireen? Okay, so that's your role, to argue the toss. So, but before you argue the case, you've got to get your basics correct, and that's why I want you to present your material in a professional manner, and I want you to be able to cite your material. There's a comment online on the chat facilities, a temptation to try to play the role of the judge instead of the advocate and to abandon arguments because you've made up your mind that they won't be successful. And that's a really good point. So thank you very much in relation to that. Okay, so, and use that as a comfort to you rather than a confusion. Look, just a few things about the first assessment. Overall, I was really happy with the standard of the work. I think most people present their work very well. The content was good. There was a fair degree of subjectivity in determining the principles that one can draw from a case. So a few of you scored very well, even though you promoted slightly different arguments or slightly different emphasis. And the important thing is that you draw material from a case that you think is arguable. In other words, when you're looking at a case, you might think that a certain statement by this particular judge is something that you can hang your argument upon. Other people might think, no, it's a different judge, it's a different passage, and it's slightly different principle. Look, it's possible that you're both entirely correct. Now, how do I put this way? Everybody thinks that their dog is the best in the world, and everyone is correct. Does that make sense? So you might think that your case, your argument is the best case you can advance. Someone else may say a different argument is the best case they can advance. It's possible that you're both right. So keep that in mind. In terms of the next assessment work and the assessment work you do in the future, you can now consider being a little more creative. This first exercise that we had was really pretty straightforward. You know, we're reviewing a case, we're reviewing some legislation. It's pretty straightforward. So there's not a lot of room for manoeuvre. But as we proceed further, the second assessment piece, for example, you can become much more creative if you want. And you can use flowcharts, or you can use other means that you may not necessarily think about. Photographs. Have a look at the textbooks and the way in which things are described. So your job is to communicate. If you feel that writing the text in the usual format is the way to go, then that's fine. But if you think that you can describe something in a more inventive style, then go for that. That'd be great. Now, you know that I'm not very keen on dot points. That's a degree of subjectivity. Other people may say using dot points or enumerated passages is absolutely the clearest way to communicate this matter. And if you feel that that's the way to go, then please do that. But do make sure that you cite your research appropriately. And if you've got any concerns about that, make sure that you look at the quick guides on the AGCL and have a look at the way that textbook writers and judges cite their material and go from there. All right, now, when you're thinking about the topic that you're presented with, and I'm saying that your job tonight is to argue the case, bear in mind that it won't necessarily be something that's in black or white, in the sense that there's not necessarily going to be a right and a wrong answer. There are plenty of shades of grey, as we say. So, and be wary of a simplistic answer. Be wary of a straightforward, well, it is this, because it may not be. And it may be that there are different areas of practice or different principles or different things that you can argue. And we see that in statutory interpretation. You know, it goes to the High Court, and the High Court is concerned to make a decision in relation to something which, on the face of it, should be a pretty obvious answer. And yet they don't go with the obvious answer because they think about the context and the purpose, and they go back to those basic principles. And what it tells me is that there's usually an argument that you can put up even against something that looks to be pretty obvious. So keep that in mind as you progress through your studies. Just a few things on collaboration. I do encourage collaboration. I think it's a really good way to study, and we've seen some really good examples of that through UCrew. When it comes to an assessment piece, I'll provide some information, but I will back off. You've probably noticed that already, so keep that in mind. But you are allowed to share some ideas in a general sense. When it comes to the final assessment, there may be a rule where we don't allow that so much, but generally speaking, you are entitled to discuss these matters. And thanks very much. Now, is it my webcam cutting out? Right. Hopefully you can still see me. I'm getting a note saying that the internet is unstable, so I apologise. But if it becomes really bad, just let me know. Thank you. The sound is dropping out as well. Oh, okay. Can't see me either. All right, I'll see what I can do. Just bear with me a moment. Okay. Not too much sound and some missing words. All right. I'll try to speak as clearly as I can. There is one thing that I do want you to do, and that is to take some time away from the usual material and to consider looking at some material by Judge Moore's own. Now, that's a little old. It's material that I put together a couple of years ago, probably before His Honour was appointed as a judge. but some really excellent material in relation to courtroom ethics, and I urge you to have a look at that. Okay. Still difficult to hear me? Hopefully that will be better. It's just a very poor internet area where I am at the moment. Okay. Sounds better? All right. Now, in terms of your textbook today, you would have noticed that the important decision is Project Blue Sky against ABA. Now, I'm just going to ask for a quick poll to keep you on your toes, and I'm going to ask you this. In 3 letters, either PBS or ABA, can you tell me who won that case? And you can just use the chat facility. Who won, PBS or ABA? See if you've been doing your reading. Project Blue Sky versus Australian Broadcasting Authority. We'll come back to the case. All right, we're starting to get some answers now. Who won, PBS or ABA? I've got answers from Leonie and Sharon. Now we're starting to see a few others, and we're seeing a theme come through. Okay, so PBS is the answer. So well done, those of you that got in with a quick response there. I will come back to that, and hopefully you can hear me and see me pretty well now. Let's just talk about the chapter that we had for our reading today, which is chapter 7 of your textbook. I also want to refer you to 2 other texts. One, for those of you doing Introduction to Law, you're familiar with this one, The New Lawyer by James and Field. And the other little textbook is this one. It's called The Australian Legal System. And there's a passage in there that I really like in relation to delegated authority. So, in fact, I might deal with that now while I've got it on the screen. And the reason I'm mentioning this is that I find that students have difficulty with the concept of delegated legislation. So if you do find this text, Australian Legal System by Carbon, I'll extract the material and put it on the website for you, but it's some really good explanation of the way in which delegated legislation works. So keep that in mind, and as I said, I will put that on the material on the website to explain it. Does anyone have difficulty with delegated legislation, that concept, or is everyone okay with it? Would anyone like to explain it for us? No? So we're talking about delegated legislation. What does that mean? And why is that important to... Yep. I cut someone off, sorry. Okay, we'll move on. Yep, so regulations. I'm getting some chat comments coming through. Any others? Lawmaking delegated to the state.
Are they rules and regulations that are governed by subordinate legislation, or is it all the same thing? Mm-hmm. Sorry, my throat.
No, that's all right. Yep, no, that's very much along the same lines. So I really want you to get an idea of how this works in practice, and I will put some notes on UCRU or on Modal in relation to that. But so a couple of things that I want you to do, apart from the ordinary reading and the exercises, have a look at what Judge Morzone has to say, and also have a look at the issue of delegated legislation. Okay. Now, from the textbook, one of the first headings is ordinarily the meaning is the ordinary meaning. Many words have different ordinary meanings, and the example in the textbook is the word made, which has a whole range of different meanings. The example is made. Now, the example in the textbook relates to someone who's injured as a result of trying to recover something from the overhead locker. Do you remember reading that one? And I'm going to ask you to put yourself in this situation. Someone comes to you and says, I've injured myself. I was getting something from the overhead locker, and the insurance company says that we will only pay in circumstances where you were wearing your seatbelt. Do you remember that exercise? So someone wants injuries, compensation for injuries. They try to get something out of the overhead locker. They're on a tour bus. They were injured. The insurance company says, the policy says you can only claim if you were wearing a seatbelt. They say, I was not wearing a seatbelt, and can I claim? Put yourself in the advisor in those circumstances. Think about those comments that I was making earlier about it's not just black and white. I am sure that many people would say, you know, in a quick consultation, I'm sorry, you don't have a case. The insurance policy is very clear. You can only claim if you're wearing a seatbelt. You weren't, so I'm sorry, it's just not, you don't have a case to argue. The point that I'm trying to make, not very well, but the point I'm trying to make is that if you were the initial person consulted by the plaintiff in the case of Insight Vacations against Young, you may have sent someone away who had a really good case because you were looking at the case from a literal perspective. Now, think about what happened to get that case to the High Court. And I'm amazed, you know, it's just really good law. It's really good legal work from the practitioners concerned. And what they said is that, okay, ordinarily passengers don't have to be seated 100% of the time. Therefore, the exemption clause only works in the ordinary situation. People do have to get up from time to time. And what that meant is that the insurance company was ultimately called upon to pay as a result of the matter going to the High Court in circumstances where the insurance policy only applied if you had a seatbelt on, but the exemption was read into the clause by the High Court saying it will sometimes apply even if the passenger is not wearing a seatbelt. And I thought that was amazing. So when you're reading these materials, ask yourself, how would I go if I was the advisor at first instance? How would I go if I was the advisor promoting someone to go to court, and then not just any court, to go through the whole system to the High Court? And sometimes you need to be prepared to argue the toss, and you need to be incredibly brave, but at the same time remain sensible about it. So I guess what I'm trying to say is read the cases, but then put yourself in the position of what would I have done knowing these facts if I was at the community legal centre giving someone advice at first instance or a fixed fee consultation. And I'm sure that if you're honest with yourself, many times you would say, look, it's black and white, you've got no case. Does anyone understand what I'm trying to get at? Any questions about what I'm saying?
Sorry, John, it's Monique. I have an old version of the textbook and I'm not quite sure what case it is that you're referring to. Do you mind just providing the details of that, please?
The case is Insight Vacations trading against Young. Now, does anyone have that page reference? And no, I don't. Yeah, so it's on page 143 of the second edition of the text. but I don't know if it's in the first edition, I'm sorry. So it's Insight Vacations Against Young, 2011, 243 CLR at 149. Okay, we'll move on then. So Shireen's made the point, yes, be creative, which is right. You need to be creative in your thinking as well as much as anything else. So a technical or legal meaning may be used as well. And there's the case of Collector of Customs against Agfa Gavet. And that was the case about the silver dye bleach. And there is the issue of current meaning, Coleman and Power as well. Look, what I might do is invite you to read the text yourself. I've got notes that I have here, but it may be appropriate to look at some of these weekly problems. And I know I'm behind in the weekly problems, so while we've got a chance, let's have a look at the weekly problems and let's go back to week 4, problem 1 of week 4. So I'll try and get that on my screen, and if you could do the same thing as well. And the pages are different. Sorry. In terms of that commentary. All right, so do we have that, have we found that first problem in week 4? And the problem was, but surely one must start with the context of the provision itself. After all, the search for context of a provision is important. Now, we had some really good answers on this. Now, and I've identified a couple. Does anyone wish to provide some comment about what we mean, what we understand context to mean? Give some examples, and can we think about contentious legislation? Any volunteers? Alan, have you got your notes there handy?
Yes, I do, John. I'm just scanning them. My response was basically about the need to think about context at a number of different levels, and particularly in sensitive areas such as, I mentioned the Queensland Mental Health Act, the new one that's going to come into force next year, which has lots of highly sensitive topic areas in it. And I'm just trying to find the point that I came to, but basically I think that I said that we've got to be comprehensively aware of the purpose of the legislation and the richness of that, the complexity of the context, in order to be able to make sense of it and apply it.
No, that's a really good answer on the run. Thank you very much, Alan. And if you haven't read that response, that's one of a number of very good responses to that question that you'll see online. Vivian, do you wish to make any comment as well? Because you've provided some good commentary there.
Well, the context, that's the context, the language that precedes and follows a series of words, such as a particular clause or sentence.
Yep, thank you very much for that. And so there were some other very good answers there as well. Does anyone else wish to add some commentary in relation to that first question from week 4? I know we're going back a bit, but I'm in catch-up mode tonight. All right, we might move on then to the second problem of week 4, and this was discuss the case example at page 71 of your text dealing with the Victims Support and Rehabilitation Act, 1996. Did it result in a fair outcome? Now, this was the case which dealt with the 2 words, symptoms and disability. were the words from memory. Does anyone wish to make any comment about that one? Problem 2 of week 4.
Okay, sorry. It's a little while ago, but if
Yeah.
memory serves,
Yes, thanks, Leona.
excuse me, I think I put down that it resulted in a fair outcome because there were 4 possible payouts. And the last one was, it all turned on the end. So it was just something in disability, symptoms and disability. Is that right?
That's it? Yep.
So I said it resulted in a fair outcome because even though he had shock and, you know, in some capacity he would have some effect on his life after the accident, it wasn't serious enough to be able to get the larger amount of compensation that was for probably the more serious cases.
Okay.
A little bit rough around the edges because it was week 4, but I think that was the general.
Again, like Alan before, particularly a good answer on the run from memory, and I saw your answer, and you made the comment that I liked, that resulted only in the most serious cases being eligible for the larger payout of compensation under the Act, which in that case didn't meet the criteria. Now, did anyone have a different view on that? Bearing in mind, of course, my comments that you can both be entirely correct, even though you may come to a different conclusion.
John, I've got a comment.
Yes, Alan?
I can't quite remember the full substance of why I made this comment, but I thought there was some inconsistency in the reasoning of the judge. He seemed to be really stuck on the use of the word and it contrasted, I thought, with his reading down of the purpose of the statute, where he interpreted it to mean that compensation is not for any and all victims. So I found that a little bit of a jarring contrast.
Yep, and I saw your answer there as well, Alan, and I earmarked that as being something which indicates a different approach to the approach that Leonie took, but both very good approaches nevertheless. Now, does anyone else wish to make any comment about problem 2 of week 4 before we move on? All right, so let's have a look at problem 3 of week 4, which was to do with Kelly against R, which was the case example on page 82 of the text. And this was the case, I'll just paraphrase it, where we had the confession in relation to the issue of murder, and the question was whether or not the confession was one that was able to fit within the terms of the legislation. It was Tasmanian legislation. Confession under the Act was defined as meaning a confession or an admission made by an accused person and had been made in the course of official questioning, which was defined as being questioning by a police officer in connection with the investigation of the commission or possible commission of an offence. You might recall that this was the case where the defendant initially made a statement, then retracted that statement, and on the way back in the car said something to the effect of an apology to the police, saying, look, I'm sorry, I was just playing the game, no hard feelings, you know what it's like, something to that effect. So the question was, in that case, before the High Court, as to the admissibility of the statement made by the defendant, and it turned on a definition of a consideration of whether it was a confession in the ordinary course of in the course of official questioning during the course of that investigation. So that was what that case Kelly was all about. And again, we had some very good answers. Now, does anyone wish to offer any thoughts or opinions about the way in which the court dealt with that case? Okay. So, Vivian, do you wish to make any statement?
I think when the judges took into consideration the literal rule and the mischief rule of statutory interpretation of Section 8 of the Criminal Law, the Criminal Law Detention and Interrogation Act, 1995, Tasmania. Those things played a lot of, those two angles, looking at the literal rule and the mischief rule, somehow resulted in the outcome of the case. The issue of, I can't recall all the facts of the case now because I read it it's quite a long time now. But he appeared to have he didn't get any penalty. The penalties I expected him to have because those things were said outside the court. He made a confession, quite all right, but the police couldn't present it as evidence.
That's right, and that was what that case was about. So thank you, Vivian, for that contribution. That's excellent. Alan, did you wish to say something?
Yeah, I agree with Vivia in that I was surprised that he didn't receive the penalties, and I thought that the broader context of the public outrage at the possibility of police manipulating confessions potentially swayed the judges in their thinking about this, when I thought that in fact there was a clear pathway for Kelly's statement to be admitted as evidence.
No, thank you very much for that. And you made comment about an interpretation frenzy over the case, possibly driven by the contextual factors of the public's outrage at the possible manipulation of confessions by police in those circumstances. So thank you very much for that. So as we speak, I'm just looking on the Moodle site now. Leonie, you also provided a very good response. Can you recall that? And I'll just call up, we had some very good ones. Melissa's was good, very good. Monique's was very good. And Sharon's. There were others as well, Grace. So I'm just have a look for yours, Leonie. May prompt your memory. I'll just share the screen.
Which one are we on? Sorry?
Yep, it's to do with Kelly against R. It's problem 3. And I'm not sure if I've successfully shared this screen or not. Can you see?
Oh, you're frozen.
It's frozen, has it? Boy, I don't know what's happening in our area at the moment. Can you see me?
Yeah, it's black and it's now.
No, okay.
No, you're still black.
Still
Oh,
not
the
there.
screen's black, I should say.
Okay. Yeah.
No.
Let me just see if we've got it right. No,
Oh, you're now.
we're not.
Gone.
What can you see now? Anything?
It just says John Milburn has started screen sharing.
Oh boy. Okay.
Oh, there we go.
Can you see something? I just stopped the share.
Yeah, I can see it now. Oh, did you?
Is it gone again?
Yeah.
Right. What have we got there now? Nothing?
Same grey screen.
Oh,
Actually, I'll just go back to my phone.
Okay.
Screen share it. That's your face.
All right. Hello. I'm back. Technical difficulties tonight. I don't know if I want to attempt it again, Leonie, but I could
That's
try.
all right. I've got it. I brought up the Moodle site where I put it in.
Okay. And others probably able to access Moodle site as you go as well.
Yeah. This one. Oh, that's right. So I just put the deciding factors in the case were how narrowly to construe the phrase in the course of official questioning and whether there should have been a time limit implied when it was clear that the language in the legislation didn't state a clear time period.
Okay.
And since Kelly voluntarily made an admission on the rooftop about his guilt and signed it prior to undertaking a formal interview, at what point should a person making a confession and or admission be videotaped so that it is admissible pursuant to Section 8 of the Criminal Law and Detention and Interrogation Act? And whether there was a miscarriage of justice admitting the impugned statement Kelly made in the car park to which there was given the overwhelming evidence against him.
Very
I'm trying to
good.
remember.
Okay.
Yeah.
Thank you. Excellent. All right. Well, look, we might move on then to week 5. If you've got access to your Moodle site, we'll have a look at problem number 1. And that was to do with intention and purpose and a request for you to explain the concept of objective intention. So problem number 1 of week 5. Now, Sharon, have you got your response there handy? I could share the screen, but I'm not sure I'm game to do that. Now, has anyone else got a thought? Got any thoughts on that one? There were some very good responses. Monique?
I'm just reading through my response.
Yeah.
So,
Takes a while to recap.
I said, although intention and purpose initially appear to have like meanings in relation to statutory interpretation, they can be differentiated in the following way. The purpose, I said, why is the statute required and who is it directed at? Whereas the intention, what does the statute aim to achieve and how will it be brought about? That may be taken straight from the textbook. Sorry if it is, I can't remember. And I've said that I see the role of intention in statutory interpretation to be used as a supportive mechanism in determining the construction which would most closely align with the purpose of the Act.
Thank you for that. Excellent. All right, any other volunteers in relation to a response to the first question of week 5? All right, perhaps we could move on to the second question. That was to do with Maxwell and Murphy, and that was the case that formed the basis of the exercises for pages 96 to 98 of the text. I'll just get you to refresh your memory on that one. So this is where a person was knocked down and there was the issue of when the action was brought and the time period, bearing in mind that the legislation was amended at that time. Any thoughts?
I'm going to go again.
Thanks, Leonie.
I said no, the case wasn't in accordance with Jaeger VR because I said that in Parliament intended originally to include the 3 types of cannabis in the legislation, but it erred linguistically in defining cannabis as a single genus. The case of Maxwell or Murphy v. Maxwell would have allowed the amendment to revive a new liability against the negligent driver that had already expired and would have asked the judiciary to change a whole time period to accommodate the widow, which was not the intention that Parliament had when it made the amendment.
Thank you. Any other thoughts in relation to that? Thank you, Leonie. Sharon? If I'm not putting you all on the spot too much.
I put that the cases were very similar because the courts read into what the intention was when legislation was passed, which is why both cases were dismissed, and there was no leeway and the electoral rule was adopted.
Great, thank you. And again, there were some excellent responses here.
John, can I
Yes,
add a response?
Yes, thanks.
I thought there was a parallel here. I was attracted by the comment that a statute can't revive a right, which was part of the discussion in Kiddo and Taylor. And I thought in the same way, a specific term shouldn't be expanded to include a whole range of other items in that term, in the same way that a statute can't revive a right.
So that's very good, and what you've done is brought in that issue of retrospectivity, which is of course relevant in that case. So thank you for that response. All right, does anyone else wish to contribute something in relation to that question of Maxwell and Murphy? Okay. Well, let's move on to problem number 3. And Dakota's got a few questions which we'll get to soon. Now, question number 3 was in relation to Comcare and Thompson, and this was on page 89 of the text. You probably noticed that some of these questions you refer to the page number of the original text, not the second edition, but I'm sure you've all found your way around that issue. All right, so any thoughts about Comcare and Thompson? Volunteers?
It's Monique. I thought this was quite interesting, actually, this case, and just reading back on my notes, I felt that, oh, now I've lost it, hang on, sorry. I felt the decision handed down by the AAT adopted a rather broad approach to construing the relevant clause and extending the provision to include an additional subclause. I felt was a quite extreme example of principled dynamic interpretation and was walking a fine line between the role of the court to interpret as opposed to legislate. You're on mute, John.
No, thank you very much for that. And I think, Leonie, you picked up on a similar point, raising the difference between the dynamic or pragmatic interpretation against the static interpretation, talking about the progressive interpretation in the spirit in which it was originally formed. So again, some excellent answers on that one as well. All right, thank you. What we might do then is just move quickly to, well, actually we might stop there and we can resume with week 6 as part of our catch up next week, because I know, Dakota, you've got a couple of questions that you'd like to ask.
Yeah. Just to do with the assignment, I've got a few questions. I've read in here that it says she's a volunteer, and then I've also read it says somewhere an employee. So I just wanted to know, does she get paid or not? Has she been employed? I'm just a little bit confused with that.
Yeah, I'm not sure I can provide any answer to that one now. I'm sorry. And I'm always reluctant when it comes to too many specifics on an assignment question. But you can highlight that point in your answer if you feel it's important.
Yeah. Also, before earlier on, I was trying to speak to you, but I don't think it was working. When you were saying at the start of the lesson something about inventing which format we use, are you meaning like an email or something along those lines? The way we present it to you, as if we're speaking to our client?
Yes, so the way it's presented to me, of course, is uploaded in the usual manner in a Word document. But within that context, yes, you can consider it as an email or a letter or an opinion or an advice, or whichever way that you feel provides the best opportunity to showcase your answer to me. But within that, but beyond that, you can use flowcharts or incorporate pictures if you like. So lots of different ways you can do it.
Okay, and just also for the Queensland Firefighters Manual, this you made this up, didn't you? This is fictional. You made that? No.
Yes.
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 I keep reading it, and then I'm getting myself confused.
Yeah.
Because section 17. How would I reference that? Have you also just made that up and added it on to the manual, or is that?
You can assume that all of that is made up. So the legislation is not real.
And so section 17 about the manual, that's not real either, is it?
No.
So I can't. How do I reference that in my?
Just when it comes to referencing material, particularly fictional material, it's more difficult, of course. But you can pretend it's real, just refer to it as best you can.
Okay, and that's all right. So I just had one last question. No, I think that's all of it actually. Yeah, sorry, I was just getting myself confused, and I just wanted to double check those things before I started writing the wrong thing, referencing the wrong thing.
Thank you for that. Does anyone else have any questions about the first or the second assessment piece? All right. Well, thank you very much. You've all been very patient tonight. You've all with the technical issues, and thank you for your contributions. And I'm sorry that I let myself get behind in terms of the tutorial questions, but next week we'll kick off with week 6, and hopefully we'll deal with the tutorial questions for weeks 6, 7, and 8. So I'll stop the recording now. Thank you very much. Yes, Dakota?
I just thought of one last thing that I didn't ask. The Act, as I read it, has it actually been made effective yet, or it hasn't, the one you've made up?
I can't recall. Sorry.
Okay, because I'm just not sure as I'm reading that if it is effective. I think it speaks in both tenses a little bit, and I'm just not sure if I tell her that this has been.
Yeah, sure.
I'm not sure.
Look, I suspect, and it's a while since I wrote it, but I suspect that if it's referred to as an act, you can pretty safely assume that's an effective piece of legislation.
Okay.
But if that has an influence on your answer, then you can always raise that and put that in. So raising those sorts of scenarios is often a good thing to do. You know, to say, make a statement, I'm working on this assumption, but if not, different consequences may flow.
Okay.
Right.
Thank you.
Dakota.
Thank you. Sorry, everyone.
Okay. All right. No, don't apologise. So thank you very much, and we'll see you all next week. All the best. Bye.